instance, you're probably not going to be okay. And that's wrong. And we need to fix that. And that, simply put, is why Koch is involved, why I'm involved, why Charles Koch is so passionate about it, and why we're here today to support what Representative Scott and Sensenbrenner are doing. Now, we believe passionately at Koch, as Van mentioned, I think both parties do, but we do for sure, in individual liberties and the Bill of Rights. And we also agree strongly about limiting government overreach, particularly in this area, because the overreach is so profound. It's life, liberty, property, and the pursuit of happiness. And we also want to help remove obstacles to opportunity for everyone, but particularly the least advantaged. So if you put all that together, criminal justice reform is the place you need to be from a moral perspective, from a constitutional perspective, and from a fiscal perspective. And as Representatives Sensenbrenner and Scott have mentioned, the fiscal perspective becomes a moral perspective. Because all the money we're spending on incarcerating people who don't need to be in prison, we're not spending on education, we're not spending on mental health, other social services. So there's a moral case there as well. So if those are your goals, you've got to be involved here in the criminal justice movement, whether you're Republican or Democrat, whatever it is. Because if you want to help the disadvantaged, this is the place to be. They are the most profoundly and negatively impacted by the current system, without question. And the current system is the most dramatic example of government overreach. They're literally taking away life, liberty, and the pursuit of happiness. And it's oftentimes for nonviolent crimes, particularly at the federal level, and that's wrong. And from a fiscal perspective, the system, all the states, federal government, the criminal justice system from beginning to end is $250 billion a year, we think. Start to finish, it's a lot of money. And there's $80 billion spent annually on incarceration at the state and the federal level. Just on incarcerating people. And that's 3 to 4 times more per capita than we spend on education. Go on and on about the numbers, the number of people in this country that have a criminal record. It's 1 in 3 adults at this point. The number of people incarcerated, 1 in 100. The number of children without a parent, it's close to 3 million because of incarceration. It's distressing and disturbing. Because as a nation, we over-criminalize conduct, we overcharge individuals for certain conduct, we over-prosecute, we over-sentence, we over-incarcerate, and then on the way out, we overburden people after they've served their sentences, and they're trying to put their lives back together and re-enter society, which make it impossible for them to get a job, to get a loan, to be with their families, to be in public housing, you name it. So we believe there needs to be comprehensive reform of the system in a way that enhances all of these things, and it enhances public safety first and foremost. It's consistent with the Bill of Rights, and it treats everybody in the system with dignity and respect and as an individual. And that's everybody in the system, the accused, the convicted, the ex-offender returning, victims, and very importantly, law enforcement, everybody, because the system now is a disservice to all those groups. And that's why we're excited, because I think the State Justice Act can help us get on that road, down that path, the right way. Now, you'll recall the bill was introduced in late June. Some of you were at the event. It was very exciting. It had broad bipartisan support. In July, as Van mentioned, the Speaker voiced his support for it, wanted to see it go to the floor for a vote, and was very excited about criminal justice reform, as are we. We favor that as well. Then in August, House Judiciary Committee Chairman Goodlatte announced, along with Ranking Member Conyers, that they would introduce comprehensive bipartisan criminal justice reform legislation when Congress came back now, this month. So we're very excited that Chairman Goodlatte also agrees with this, and that he's in favor of comprehensive criminal justice reform. And I really look forward to seeing what he's going to put out, and what he's going to propose, and what it looks like, because I think that the more bills, the more voices in this, it's important. But we do know now that the reforms that are in Representative Scott's and Representative Sensenbrenner's bill, they're all about bipartisan reforms that have worked in the states, particularly the red states, right? Georgia, South Carolina, Texas, Oklahoma, South Dakota, Mississippi. And these states and many others have reformed the criminal justice systems in their states. It's enhanced public safety, it's reduced crime rates, it's reduced spending on incarceration, it's reduced incarceration rates generally, It's addressed recidivism issues, it's reunited families, and it's helped give people a chance at a productive life. Now, I'm not a brain surgeon or a rocket scientist by any stretch, I'm a lawyer, but if it's working in the states, common sense would seem to dictate it should also work at the federal level. So, currently our federal system is a major barrier to opportunity for all people who get caught up in it, but particularly the poor who make a mistake, especially a nonviolent, drug-related one early in their life, and you're branded with it for life. It limits your ability to participate in American life fully, and has devastating costs and consequences that we've already been alluded to. Now, I saw a lot of this firsthand when I worked as a prison guard up in Worcester, Massachusetts, in the 1980s. And there I saw a number of former classmates and neighbors, kids I grew up with, who I'd lost touch with for good reason, because they had dropped out of school, become drug addicts, gotten in trouble with juvenile system, and then up to the adult system. And they were now incarcerated when I was working there. And there really wasn't much difference, at least that I could see, between me and them. We went to the same school, same church, same neighborhood, played in the same sports leagues and all that. The difference was I had really strong parents who would kick my butt if I stepped out of line, and they held me accountable. And when I did something wrong, I heard about it, and education was stressed, and hard work was stressed. But absent that, it could have easily have been me that wound up in the wrong place at the wrong time and ended up there. It's much what President Obama said, that Van alluded to at the beginning here today. There before the grace of God go I, and that carried with me to this day. So, my former classmates and neighbors that were in prison, when they dropped out of school and developed drug problems, they weren't bad people. Some of them became bad people, but they got caught up in the cycle of despair and poverty and couldn't get out of it. They made bad choices. There's a couple that probably needed to be there for a long time, but not a lot of the kids. They were okay, but they just couldn't get out of the system. They didn't have the support. And 30 plus years later, we're still seeing that play out every single day. And that's wrong. It was wrong then, it's wrong now. So we need to do what they're doing in the Safe Justice Act and re-examine what conduct we label as criminal and how we choose to treat those that we branded as criminals while they're in prison. My point of view, working in a prison, your goal is to make the person better when they come out than they were when they went in. That's your job. And so when they come back to society, re-enter society, and they are over 95%, they'll have a chance at a productive life. That's in all our interests, because we don't need to be tougher on crime. That's just a slogan and an empty slogan. We need to be smarter about all these things. And hopefully the Safe Justice Act and its incorporation of reforms that have worked in the states, and there are other bills in the House as well. We've heard about sentence reform and corrections reform that may be coming from the Senate Judiciary. I'd like to see that as well. Hopefully all of this will begin to move, and we, as Van said, by the end of the year or Easter, opening day, whatever, we can get something signed by the President. That would be wonderful. And we can begin to reverse this trend, because it's cost a lot of money, a lot of lives, and just a lot of despair and poverty. So, we commend Representative Sensenbrenner and Scott for their leadership, and all the other members of Congress, Republican and Democrat, who are leading the way towards real criminal justice reform with their own bills and initiatives. And with these reforms, hopefully, we can fulfill what Thomas Jefferson said is our most sacred duty as a government, to do equal and impartial justice to all its citizens. So thank you very much.
Good, all right, so the next three speakers represent a point of view that I think is really critical. The point of view of law enforcement itself, as well as the point of view of people who have been victimized by some of the crime that we're talking about. And so we're going to hear from three more voices. I was going to drag Sheila Jackson-Lee up here. She sent me a note that she couldn't do it, but she's rooting for us, so I appreciate her. And then after we hear from these next three voices, we are going to get a panel discussion going. I believe Molly from FAM is going to orchestrate a panel discussion to get some of your questions answered. But first, I want to bring up Tim Heaphy. He's been a prosecutor. He's had to actually look at the law, look at the facts, look at the victims, look at some of the offenders, and try to find his way toward justice from that point of view. it is a unique and special and important point of view that we, I think, value greatly. We don't hear from enough. He is also somebody who was a federal prosecutor in the home state and district of Chairman Goodlett, who has the fate of this bill in his hands and in his committee. So I think we are especially interested in hearing from Tim. Let's give a big, warm welcome to Tim Heaphy.
Thank you, Van. Good afternoon, everybody. As Van said, I'm Tim Heaphy, and I'm the former United States Attorney for the Western District of Virginia. I was proud to serve in that capacity for about 5.5 years, appointed by President Obama, and just recently left and am now in private practice at the Hunt & Williams law firm. When I was the United States Attorney, I, as Van said, was responsible for all federal cases that were brought in half of Virginia. And every single one of those cases, whether it was a drug case or a white-collar crime case, whatever it was, came across my desk, and I had to make a decision about whether or not it was an appropriately charged offense, whether it was the kind of case we should be doing, and ensure that it was applied, that the standards that were given to us, the rules were applied equally. And I took that obligation very seriously. I also had a chance to get involved in some policy discussion at the department. The Attorney General, Eric Holden, appoints 15 U.S. attorneys from around the country to come to Washington once a month, meet with him and others at the department, and talk about policy issues, examine whether or not the things that we are doing, those rules that we apply are fair and are just. And as a member of that committee, which was chaired by Loretta Lynch, our current Attorney General, we looked hard at some of those rules, particularly drug sentencing. And we came up with something called the Smart on Crime program, which I want to talk about a little bit today. But before I do that, I thought it might make sense to give you a little bit of a very brief primer about the federal drug laws. And it's important that we start from a common set of facts when we talk about this issue, and I think I just want to give you maybe just a couple of minutes about what the rules have been and how they have evolved. I became an assistant U.S. attorney. Before I was a U.S. attorney, I was an assistant U.S. attorney. And I spent 12 years in Washington, D.C. I was hired by Eric Holden when he was the U.S. attorney in this city. And for 10 years, I tried cases in the District of Columbia, a lot of drug cases. And then I moved to the Western District of Virginia, where I currently live, tried a bunch more cases. So I've worked in a big urban environment and in rural communities, turning the wheels of this system. And that's really what informs my perspective on this issue, more than the policy discussion, more than my time as an official in the department. It's my time in the trenches as a line prosecutor. When I started in 1994, I became a federal prosecutor. The rule that applied to every person like me, whether it was in D.C. or in California, was that we were duty-bound to charge the most serious, readily provable offense. This was called the Ashcroft Memo. Attorney General Ashcroft issued a memo which directed us that on the facts of any particular case, our responsibility was to charge and insist on a plea to the most serious, readily provable offense. The idea here was uniformity, that we want to make sure that we have due process around the country, that the rules are applied equally. Shouldn't be that somebody in Massachusetts gets a radically different outcome than somebody in Alabama. So I, applying that policy, would prosecute people for the most serious thing that they did. And that involved, when it came to drugs, very aggressive use of mandatory minimum sentences. Under the federal code, quantity is what dictates whether or not a mandatory minimum sentence is available. It was essentially a policy decision made by Congress years ago that the quantity of the drugs involved in a particular case is kind of a proxy for dangerousness and therefore enhanced sentencing. So if someone was involved in selling over a certain quantity threshold of cocaine or heroin or marijuana, whatever it was, then I was duty-bound to charge them in an indictment with an offense which carried a mandatory minimum sentence. It used to be 5 grams of crack cocaine, very small quantity. If you were charged by the United States Department of Justice, and you were involved either yourself in selling 5 grams or you were involved in a conspiracy that was generally collectively responsible for that amount, then I had to charge you with an offense that carried a 5-year mandatory sentence. If you had a prior conviction, it doubled to 10 years. And you didn't have to touch anything. You, if you were in a conspiracy, were responsible for what the conspiracy did that was reasonably foreseeable to you. So if you owned a house and there were drugs being bought and sold in that house, and you were aware of that and allowed that to occur, you were a co-conspirator and therefore responsible for the entire quantity of drugs that business moved. The only way out from that, the mandatory charge, judge couldn't depart below that. He or she had to impose the sentence based on that quantity if that quantity was established. The only ways out were something called the safety valve, which was the only offenders eligible for that, had no criminal record, and truthfully disclosed what they had done. Or the prosecutor could give you what was called a 5K motion, substantial assistance to law enforcement. Very strong incentive for people to cooperate. You're going to get 5 years or 10 years in prison unless you cooperate with us and tell us who was your supplier. And we used that aggressively to work up the chain in drug organizations, get information about people that were importing, manufacturing, cutting, selling those quantities of drugs. Now, mind you, all of this was completely concurrent with state law. There's not a state in the country that doesn't have drug statutes. So what we were doing could have been done down the street in a state prosecutor's office. And that really varied by place as to whether a case would end up in federal court or state court. But the rules were essentially the same. We had the mandatory minimums, which a lot of times led agents to come to us and say, y'all can get 10 years on this guy. Our judge isn't going to be quite that harsh. So we think he's worthy of treatment in federal court. And we would say, yes, bring him over. Now, the result of that was a huge increase in the prison population. Because we were duty-bound to charge those lengthy mandatories for anyone who was involved in a conspiracy, we had a lot of people who were going to prison. And you heard the numbers from Congressman Sensenbrenner before, an 800% increase in federal prison population. Half of the people in federal prisons today are incarcerated on drug offenses. And there's a huge disproportionate impact on communities of color, because most of those people are people who are African American or Latino. So as we played by these rules, we perpetuated a system that led to the very problem that you heard Mark talk about, that you heard everybody here talk about. Lots of people in prison who were nonviolent, who were essentially drug sellers. And these were good people, mind you, who were doing this, right? I was doing my job. I was doing what I was told to do. And I wanted to do justice, but I oftentimes felt when I was standing there in court and there was a young man going to prison for 25 or 30 years, I'm questioning whether that was justice. So I got a chance finally to be a U.S. attorney, to go talk to Eric Holder and others about whether or not these rules make sense. And we changed the rules. We didn't change the sentences, that's still to come. And we heard about legislation that might do that, but we changed the way in which we exercise our discretion. And there were two motivators for that. One was resources. I was U.S. attorney at a time in which sequestration was implemented, where I had a hiring freeze for lengthy periods of time in my office, where I couldn't hire new lawyers as we had openings, where there was a shrinking pie of resources available for us to do our work. And that's driven by the shrinking pie and the less and less money available for us, because we had this increasing expenditure on the Bureau of Prisons. Bureau of Prisons, you can't cut. People are in prison and there are basic services that need to be provided. The only things that you can cut or you can't cut back on are hiring prosecutors or giving money to FBI agents or giving money to state and local agencies or all those prevention and reentry programs that the department funds. So we were faced with a financial situation that was extreme and difficult and was unsustainable, because we had to keep funding incarceration, left less and less money available for us to do our core function. And there was a sense that a lot of people like me who had spent a lot of time in the department, that maybe what we were doing wasn't fair, that we were over-incarcerating, and we weren't really achieving the outcomes of true public safety that we wanted. And that disproportionate impact troubled a lot of people, still does. So the twin motivations of cost and fairness motivated the Attorney General, the President of the United States, the Attorney General, and all of us to look at ways that we could, within our executive discretion, do things differently. That led to Smart on Crime. Let me tell you just a little bit about the current approach of the Department of Justice that governs the discretion of the people who are out there now making these decisions. Smart on Crime forces people in the U.S. Attorney's Office to redefine a federal interest. It used to be, again, we would take in federal court any case when a state or local partner called and said, we think you can get more time. That was generally what governed it. Or we don't have enough people to do this case. Resource considerations. Can you all take it? And we'd say yes. Because in a time when the resources are ample, then we could do that. Now, prosecutors are told, make sure that there's a core federal interest, a uniquely federal interest. If there's concurrent state statutory apparatus, then the default should be that that case should stay in state court. Look for a particular federal interest before there's an intake decision. With respect to drugs, the headline for Smart on Crime is reduced reliance on mandatory minimums. The Ashcroft memo is gone, and the Holder memo thankfully took its place. Each case now gets individual consideration. You evaluate that particular defendant, that particular case, on the merits, concerned about due process and uniformity of approach, but no longer do you have to charge and insist on a plea to the most serious readily provable offense. And when it comes to mandatory minimums, the default is that the prosecutor will not charge the quantity threshold that triggers the mandatory. Only if there is an aggravating factor will the mandatory minimum be sought. If the particular defendant carried a gun, was involved in a gang or a violent crime, had a very serious criminal record, generally 4 or more criminal history points. Those was part of a large drug organization. Not just part of it, the manager or leader of a large drug organization. One of those or more of those factors must be present now for an assistant U.S. attorney to charge a quantity threshold which triggers the mandatory. And that has to be an individual decision within a conspiracy. So rather than everybody in the conspiracy, from the woman who owns the house where crack is being cooked and cut up, getting the precisely same mandatory minimum charge as the guy who's driving it down from New York City, we now differentiate. And you might charge certain participants in a conspiracy with the quantity threshold that triggers the mandatory, and others are charged, but they're not charged with the mandatory offense. There's more tailoring in terms of individual culpability within a conspiracy. And that, now, we have about 2 years of data as to how that has gone. There's also, in Smart on Crime, increased focus on prevention and reentry. Every office now has a prevention and reentry coordinator in the federal prosecutor's office. People now focused exclusively, not on building cases, but on identifying viable prevention and reentry programs within a particular district and trying to support them, direct federal grant money to them, connect them with each other, make sure they're aware of sort of best practice and successes around the country. And the goal is to pair those resources with this targeted enforcement so that we have a comprehensive approach to community safety. And then finally, there's a clemency and compassionate release program. The department actually is looking backward at some of these outcomes and identifying candidates for clemency. And the president is considering now a pipeline of cases, old cases, where people like me who said, maybe this person didn't deserve 25 years, can put that case forward for consideration for the president to grant executive clemency. And he's already done that in a number of cases, and I think more are on the way. All of this is motivated to shrink the cost of federal prisons and make our system a little bit more fair. Now, just quickly, a couple of objections to that. This was controversial within the department. When I first sort of told my office, this is how we're going to do this from now on, you know, there were a lot of people, veteran AUSAs, who were skeptical, who said, how's anybody, we're going to get anybody to cooperate with us in a drug investigation? And why isn't crime just going to go back to the level that it was in the 80s and early 90s? Crime's going to go up, we're not going to have any leverage. Now, after 2 years, those concerns, I think, are clearly misplaced. And the data shows, for instance, the number of cases that the department brings, drug cases, is down pretty precipitously. And that's predictable. With less of a difference between a federal outcome and a state outcome, then more cases are staying in state court. I think that's appropriate. I think that's right. I think the federal government ought to be, federal prosecution ought to be reserved only for complicated, multi-jurisdictional, complex patterns of crime. And stuff that stays in one community ought to be handled by the people. in that community. And that's happening. Drug cases are down about 30% department-wide, just in terms of raw numbers. Guilty pleas have not changed. The fear about leverage and people aren't going to plead guilty. The year before Smart on Crime, 97% of federal drug defendants who were charged pled guilty. The year after Smart on Crime, 97.5% of the people charged with federal drug crimes pled guilty. No change, actually a slight increase. The rate of substantial assistance, the number of federal drug defendants who qualify for that reduction based on their cooperation with law enforcement, is exactly the same. There has not been a drop-off in the ability for federal prosecutors from the DEA and ATF and FBI and U.S. Attorney's offices to get actionable intelligence and make substantial drug cases. And it goes back to what Congressman Scott said. It's the certainty of punishment that is much more effective as a deterrent than the length. And we're still using mandatory minimums. People are still getting lengthy sentences, but it's the right people. And with that certainty hanging over their head, there's still tremendous leverage for cooperation. And will crime increase? No, we haven't seen that. We do have data from the states. You heard Congressman Sensenbrenner and Scott talk about Michigan and Kentucky and Texas. These state laboratories have shown that you can reduce mandatory minimum sentences, have fewer people in prison, and actually see a significant reduction in recidivism. These laboratories demonstrate that that kind of policy really works. And these are conservative states with largely Republican legislatures that have done this. Hopefully that example carries over and people see that in the federal system it's possible to do the same. Let me just finish with an example of how this works post-Smart on Crime, and an example of how it should work if we are successful in changing the rules going forward. The biggest pressing criminal justice issue in my district when I was U.S. Attorney was opiate abuse. A huge, huge problem with heroin addiction, overdose deaths in places like Winchester and Harrisonburg, Virginia, out in the Shenandoah Valley, right along the spine of Congressman Goodlatte's district where I served. And instead, back 20 years ago, if we experienced a spike in heroin overdoses, the response would have been, we're going to go lock a bunch of people up for heroin. We're going to charge everybody. And we're going to try to arrest our way to changing that situation. We would throw a net over the community. We would essentially do a drag net. Now, instead of throwing a net over entire communities and arresting a lot of people who happen to have heroin, we're trying to fish with spears as opposed to nets. We're trying to get actionable intelligence about who the people are bringing heroin into Winchester and Harrisburg. We're not bringing the guy who buys 3 packs and gets high in the alley into federal court. He needs treatment. He needs to have help with his addiction. And if we give him that, hopefully he gives us some intelligence that allows us to build cases against substantial targets that are responsible for bringing in that poison into our communities. So it's targeted enforcement, not dragnet enforcement, not net fishing, but spear fishing. It's coupled with support for prevention. So much more attention now on treatment for people struggling with addictions and education. I have assistant U.S. attorneys that work in Winchester and Harrisonburg that are going into public schools and giving programs about addiction, about opiates and the dangers, how it starts with a prescription drug and then can graduate to something more serious, helping people make better decisions about the threat that exists, a prevention solution. And then finally, support for ex-offenders. We have a lot of people that are about to come back into those communities pursuant to reduction in the drug guidelines. It's in November, the Sentencing Commission's retroactive application of some reduction in the drug guidelines is going to result in a lot of people coming back into our communities who were charged years ago with drug offenses. And there's a real effort to ensure that when they return, there are programs available to help them with everything from basic as getting a driver's license, to paying their court costs, to housing and employment opportunities. So we have to really erect this 3-legged stool of public safety, targeted enforcement coupled with